documents to be verified by the investigating officer, and the report will be presented on the next mentioned date. In view of the submissions made by the advocate for the first accused person, the plea taking for the first accused person is deferred to 17th of November this year. Counsel for the first accused to inform his client of the date, and the investigating officer to also serve the first accused person with summons requiring his attendance before this court for plea taking on that date. With regard to bail bond issue for the second accused person, I have taken note of the submissions made by counsel on record. I have also perused the affidavit sworn by Corporal Dennis Mugambi on 24th of October 2025 filed hearing. From that affidavit, there is an indication of paragraphs 4 and 5 that the second accused has been out on police bail since the time of arrest in August 2023. It is deponed at paragraph 5 of the said affidavit that the accused persons have been reporting to the investigating officer for extension of police bail since then. The said affidavit, in my view, confirms that there is no risk of absconding on the part of the second accused. While it is deponed at paragraph 7 of the said affidavit that the accused person's places of abode are unknown, details of the second accused person's place of abode given in submissions by defense counsel for the second accused person have not been challenged. There is an averment at paragraph 6 that the complainant informed the investigating officer that the accused persons threatened him with a pistol on 26th of August 2025. The investigating officer has stated on note that that alleged threat was not reported, and he was not shown any occurrence book where the said threat was reported. That alleged threat is a serious one. However, it has not been substantiated, hence remains a mere allegation. The authority of Jeffa versus Republic, reported in 1973 volume of East Africa Law Reports at page 39, is clear that the court should not rely on unsubstantiated allegation as a basis for denial of bail bond pending trial. The principal consideration in every application for bail bond is whether an accused person, if released, is likely to turn up for trial. The material before the court indicates that the second accused person was granted police bond and complied. I therefore, for these reasons, find no established compelling reason why the second accused should not be granted bail or bond. I have taken note of the fact that the second accused person was out on police bail, of Kenya shillings 100,000. He is alleged in the particulars of offense to have obtained about Kenya shillings 35 million by false pretense. He enjoys presumption of innocence under Article 50, Sub-Article 2A of the Constitution. However, bond terms are required to be reasonable, as provided at Section 125 of the Criminal Procedure Code and Article 49, Sub-Article 1H of the Constitution. For these reasons, the second accused person is granted bond of Kenya shillings 2 million with one surety of the same amount. The case be mentioned for pre-trial on 7th of November 2025. As already stated, the first accused shall take plea on 17th of November 2025. A report on verification of medical documents and air tickets relating to the first accused person to be presented on the next mentioned date of 7th of November 2025. Orders accordingly.